Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody. Today, we have a very special guest, what I would consider a rock star in her profession. Jamie Gonzalez is a trust, probate, and conservatorship litigator. So, Jamie, welcome to the show.
Thank you for having me.
Thank you for being here. Let's get straight to it so our audience can get some very good information. Can you tell us, what is probate?
Sure. In California, probate is a court proceeding that somebody has to go through when a loved one dies. If the loved one who died did not have a trust. If the loved one had a trust, you can avoid probate. But if they only had a will or they had no estate planning documents whatsoever, then you have to go through the probate process.
Very good. That makes total sense. And what about a conservatorship? Very, very little talked about. What is a conservatorship?
Well, conservatorship has gotten a lot of time in the news since Britney Spears, but I would not say that that is indicative of how conservatorships work at all. So a conservatorship can occur in a variety of times. The most common time is when you have an elderly family member who does not have estate planning documents, so they have not executed a power of attorney giving somebody the authority to act on their behalf. So when they do not have that, or sometimes even when they do have that, but other third parties sometimes require a conservatorship. For instance, if you're selling real property, sometimes that comes up. But if a person has, let's say, dementia or Alzheimer's, and they cannot make medical decisions for themselves or financial decisions for themselves, or both. So that's the most common type of conservatorship, and that is heard in probate court as well. There's also a limited conservatorship, which is for developmentally disabled adults. So people with cerebral palsy or autism are very common examples where they cannot make their own decisions. And so, for instance, a parent would become their conservator. There's also a mental health conservatorship. I don't do those, and those are not in probate court. Those are in mental health court.
Got it. Very informative. Thank you so much for that information. Now, let's talk about exactly what you do. You are a litigator. So I guess I've heard you say before that court is your happy place?
I do love court. I've been litigating for over 22 years. It's super dorky, but when I got into probate law, I really love being in court, in probate court, as opposed to civil courts or family law or any other types of courts.
Very good. So this has happened to me many times. I see somebody requesting, they say, look, I don't get along with my brother. He's trying to sell my mother's house and they are suing this and blah, blah, blah. Please, can you recommend me to an estate planning attorney? And one of the things that I say is like, you don't need an estate planning attorney. You need a litigator. Help me make that distinction for our audience, please.
Sure. So in the most basic terms, an estate planning attorney drafts the wills, the trusts, the powers of attorney, and other similar type documents. Sometimes estate planning attorneys, when your loved one dies with a trust, will help you administer the trust, gather all of their assets, and distribute them to the beneficiaries. Sometimes they do, sometimes they don't. I stay away from that side of things, the planning, the drafting of the documents. It's when either a document comes to me that's poorly drafted and it's ambiguous and people are fighting over what does it mean, or somebody makes allegations that the person who executed the estate planning document either lacked capacity at the time they executed it, or they were unduly influenced. So often we have sibling disputes where one sibling alleges that the other sibling alienated a parent or isolated a parent or took them under their wing and they became reliant on them, and therefore they got them to sign documents that maybe favored the one sibling over another. So those are some examples of the differences between the planning type attorney and the litigator. So basically I do the fighting side of things. Hopefully we can work things out without going to court. That's always the goal, because court may be my happy place, but is not most people's happy places. And so if you can work it out in advance, that's much better for the client. And that's what I always try to do. But often emotions are run very high in these types of cases. And so sometimes it's hard to do just a straight up cost benefit analysis like you may be able to do in business litigation because there's not real emotion involved. But a lot of times there's deep-seated emotion that make it difficult to do that cost benefit analysis, or people care more about principle than the end result. And so we often end up in court for those types of things.
Now, cost benefit analysis, is that something that somebody comes to you and says, Jamie, look, I got this problem, et cetera, et cetera. Do you help them figure out, look, is it worth for us to litigate or should we settle? Is that something that you help the client do?
Absolutely. I mean, you cannot force a settlement, but you can try to get, everybody has to agree to a settlement. But yes, absolutely, we'll talk about, does it make sense to run to court? Sometimes there's a time-sensitive issue and you do need to run to court, but oftentimes we try to work it out. So for instance, I have a new case that I just brought in, and a client's received a letter from the sister, and his sister's alleging all these things. You did this, that, and the other before mom died. We anticipate that there will be a fight in probate court as to even the most basic of who's in charge of the mom's estate. So I'm going to reach out to the sister's attorney and say, hey, let me answer the questions that you put in your letter. Maybe that will allay the sister's concerns and we can avoid any kind of fight. Alternatively, maybe they go in together and act as co-administrators of the mom's estate. So everybody sees that we're being as transparent as possible and we're not trying to hide anything.
Yes, these things can get very contentious. I've had clients, before we put their home up for sale, they went in with Post-it notes to put things on the things that they wanted, and the other sibling had to do that. And if you spend any time in probate court, you know that sometimes it gets like a Jerry Springer episode. I always like to make that joke. I talk to a lot of estate planning and probate attorneys, and a lot of them, you won't believe, I'm sure you do actually believe how many, they say, I do non-contentious probate, like they do the planning side. So you essentially get to see a lot of the time the work that estate planning attorneys have done, if any were involved during the estate planning. In your experience, as you have seen these things, are there mistakes that you often run across and you're like, if only they would have done that, we wouldn't be dealing with this situation? Is there something that stands out to you?
There's a couple things. You want your trust to be written as clearly and unambiguously as possible so there can be no dispute over what does it mean. Right. So that's one thing. Another thing is, oftentimes people equate age with automatic incapacity. So if you have a 90-year-old executing documents, people jump to the conclusion that they must not have known what they were doing.
Right.
So if there's any question about a trustor or somebody who's executing estate planning documents, if there's any question about their capacity or whether they're being unduly influenced, I often recommend that they get two things. One, a note from their doctor who would have done testing about, memory failures or cognitive decline. Get a letter stating that they have their faculties about them and they can make these types of decisions still. That would be the first thing to do. And then the second thing to do would be to get what's called a certificate of independent review. It's not inexpensive because it requires bringing in a third attorney or second attorney, I apologize. And that second attorney would be a totally unrelated attorney, not somebody from the same law firm, who can come in, take the documents that have been drafted according to the client's purported wishes, have a separate meeting with the client without the drafting attorney, without anybody else, go through the documents, and opine as to whether this really seems to be of the client's true wishes and whether they seem to really understand what are in the documents. And then if they're satisfied, that other independent attorney will issue what's called a certificate of independent review and stating all of that. Now, neither the doctor's note nor the certificate are slam dunks in court, but they're just additional evidence, things to have in your back pocket to pull out and say, look, we did everything we could possibly do because we anticipated that you were going to cause problems. And we have an independent doctor and an independent attorney attesting to capacity or lack of undue influence or something like that. So those are things that I often see that attorneys do not do or have in the estate planning file, which would be helpful.
Very nice. Very nice. Good to know. These are very, very valuable information. Now, you get to see in your, unfortunately, I guess, but it's part of your business, elders who have been abused in a sense that, they've been taken advantage of. How is the approach when somebody comes to you and said, look, my aunt who has nobody has been, transferring properties and doing all these things. I need help. What is the first step generally of that process?
I mean, I would go in for conservatorship right away.
Right.
I mean, it's a big step. A conservatorship is a big step. As we all learn with Britney Spears, it takes away the conservatee's civil rights. They cannot make decisions for themselves. So you need to make sure that the standard is it the least restrictive alternative? Right. But if oftentimes it is, and oftentimes the aunt in your example is being taken advantage of, or they're getting publishers clearinghouse things and sending off money, or getting phone calls and opening up new credit cards that they don't need. And somebody needs to step in and really protect the aunts for the aunt's benefit, because this could happen when the aunt is, has early onset dementia, for instance. She's 65. She's cognitively declining, but she's physically very healthy and could live another 30 years. And you want to make sure she's not just giving money away or running up credit card debt. And so you really want to protect her, even though it is a drastic step of taking away a lot of her rights.
Right. I think that other than incarceration, it's difficult to think of something else beside conservatorship that legally takes so many rights away from a person. But fortunately, this is in place because it does protect the individual who has such issues. Now, when it comes to the litigation portion, I know that probate has, so maybe you can educate me on this as well. Probate has a limit of, the amount of expenses that an estate can incur. Is that the same when it comes to litigation, or is it different?
Well, it's not a limit that can be incurred. They just need to be reasonable.
Right.
The expenses need to be for legitimate trust or estate administration purposes and to benefit the estate, but it could be millions of dollars. It depends on the size of the estate.
Sure, absolutely.
In litigation too, it varies drastically depending on what type of litigation it is. Often if you have a trust that people are fighting over and it's being court supervised, you do have to get court approval for fees, not necessarily for administrative costs. If you need to hire a CPA to do a tax return, you don't have to get court approval. Or if you need to pay the mortgage so the house doesn't go under foreclosure, you don't have to get court approval for that. But everything has to be reasonable and for the benefit of the estate and its beneficiaries for it to be court approved.
You have the opportunity in the position that you are to be kind of a superhero sometimes. You come in and speak for those who can't speak for themselves. When you started your career, did you know that eventually you were going to end up where you ended up? Or was this something of a journey can you elaborate on that a little bit? Like, what is the journey that led you to arrive to where you are today?
Sure. So when I was a kid, as dorky as it is, I either wanted to be a lawyer or a dancer, and clearly dancing did not work out in my favor. So I went the lawyer route. I always knew I wanted to be a lawyer. And I, as a kid, didn't know there was lawyers who didn't go to court. I thought all lawyers went to court. That's what you see in the movies and on TV.
Right.
So I always wanted to be a litigator. I didn't start doing trust and estates litigation until about 15 years ago. I had been doing business litigation and some bankruptcy litigation, and I was actually on maternity leave with my second child in Hawaii at my sister's wedding, and I was miserable. I did not want to go back to my law firm, and one of my sister's best friend's husbands they were in Hawaii for the wedding, and I was complaining about how I didn't want to go back to that firm, and he said, well, we actually need more litigators. Would you be interested? And I said, I know nothing about trust and probate, and he's like, you know what? We need litigators. You have the right skill set. We can teach you about trust and estates law. So I came back from Hawaii, I interviewed, and that was January of 2008. And I started, or probably a little earlier than that, and I started in January 2008. And so I kind of fell into this area of law, although I've always done litigation, and I've loved it. I've never looked back. Probate court is a very civilized place to litigate. It's a small community of us who do this type of litigation. And so you run up against the same people over and over and again. And so people are not jerks just to be jerks. People don't paper you to death just to run up fees. They know they're going to run up against you in multiple cases in the future. So why burn bridges? In civil law, in in family law. I mean, that is routinely done, but not really in probate court. So everybody's fairly civilized. We don't do a lot of discovery motion practice. We try to work things out. We also have a limited number of judges. We have, I think, 9 judges. And so you really get to know the judges because we're in court all the time. I'm in court 3-4 days every single week.
Wow.
So the judges get to know us. We get to know the judges. And then you build a rapport. And so it's really a nice place to be if you like to litigate.
That makes sense. Now, when somebody is looking, how does, other than, what we have discussed, what are the indication that, litigation is necessary inside a probate? Is it stems from a disagreement or the feeling that somebody got taken advantage of? When people reach out to you, generally speaking, with what type of urgency do they have usually? What is the main problem that they're trying to solve?
Good question. I mean, all of those examples you gave would be reasons why people might reach out to me. And it depends on what's going on, whether there's urgency or not. You really have to have, it's called exigent circumstances. It's kind of like an emergency situation to rush into court and to get a quick hearing. If you filed papers, you're often waiting 4 to 8 weeks, depending on the type of petition you're filing. If there's emergency services, you can get a hearing sooner. An example of when there might be an emergency is if there's a trust, and I had a case where I represented the children of the person who executed the trust, and a nephew had wormed his way into his uncle, my client's father's life, had the trust completely changed, and had himself named as the trustee. And we also knew that the nephew or / cousin didn't have a lot of his own funds, so we were worried he was going to just start draining the uncle's trust for his own benefit. So we rushed in to get a restraining order to restrain him from using trust assets to pay his attorney's fees or to use for his own benefit. So that will be an example of when there's urgency, when you need to rush in. Sometimes there's not urgency. I mean, you want to get it done, but there's no need to rush. Like if somebody dies and it's a straightforward probate, you want to get it done sooner rather than later. You're supposed to lodge the will within 30 days if there is a will. But you don't have to rush in. I just have a case where the guy died in 2013 and a probate was just filed in 2022 because they didn't understand that a probate needed to be filed. So it's a little bit harder because you have to go back and figure out what the assets were at the date of death, but there's no real emergency to that type of situation.
Yes. I think there's really a lack of education in the world of probate. People, it's funny because, you mentioned something when, not this last meeting that we had, when we, just so the audience knows, we belong to a networking group of which Jamie is the leader of our chapter and does a great job at it. But I was saying something, I know myself as the probate realtor, and Jamie had mentioned, but nobody knows what probate is. And she's so right. She's so true about that. Like, until you need it, you don't know about its existence. And in our city, there are some communities that are completely underserved when it comes to probate and are just left to fend for themselves. So hopefully, when somebody Googles probate, they run across us and then they'll be able to reach out to some trusted advisors. Anyway, that was a segue.
I want to just comment. The other thing that people don't understand is if people think, most people call it a will. If I have a will, I'm good. Right. You're not good. I mean, you're fine because you've designated who gets what and what your wishes are, but your beneficiaries and heirs still have to go to court. If you just took the extra step to do a trust, which you can do at the same time as you do the will, right, you can avoid going to court altogether so long as there's no disputes.
Right.
So the will versus trust thing is a big thing that people are kind of clueless about.
Maybe we should do an episode just on that, on the will, the difference between a will and a trust. But since you brought that up, something that we talked about at the very beginning of the episode, litigation when it's a trust, there is, litigation in probate and litigation when there is a trust, and in which case the trust document becomes very important. What did they do to prepare? When somebody comes to you because they find you somehow and they want to do the estate planning, so they're not in need of litigation yet, is your procedure to refer them out to a colleague, or do you help with that, with the estate planning as well?
I do some estate planning for simple estates. If there's any advanced tax planning, I don't have the tax expertise to do that, and there's a lot of things that can be done, so that I'll refer out. But I have 3 children, so I come across a lot of families who have fairly, they have a house and maybe a vacation home and some bank accounts and some stocks. And that's easy enough. And when I say easy, I just mean under the estate tax exemption amount, which is currently around $23 million. So a lot of people fall into that category, myself included, unfortunately. And so I'll do some of those types of estate plans. It's definitely not my favorite type of work, and I don't market myself as a planner because there's a million estate planners out there who do a lot of good work. But I do highly recommend finding an attorney, me or anyone else, to do your estate plan, and do not use LegalZoom or something like LegalZoom. I don't want to defame LegalZoom, but I can tell you from experience, I have a lot of litigation stemming from estate plans drafted on LegalZoom because they didn't know how to do it right, or they didn't take things into account, or it's not properly written so everybody understands what's going on.
Thank you for bringing this up, because this is actually an interesting point. I mean, in the end, you always get what you pay for. I know, it's an old cliche, but there are a lot of online services now that provide, make your trust, do this, no, do it yourself, this. And I understand how people reach out and try to do it on their own so that they can save. But in the end, those who are left behind will have a harder time. So that's something to keep in mind for sure. Okay, now as we wrap up, I like to end with a little bit of a fun note. I have a list of 30 questions that I used to use when I ran a social club 15 years ago, and I want you to pick a number, if you may humor me, between 1 and 30, and I will ask you that question.
Okay, I pick 14.
14. Okay, what is your favorite city and why?
I think it has to be San Francisco. I lived up in the Bay Area for 10 years, and I just have so many fond memories, and I love it up there. I have a lot of friends up there, and every once in a while, I just get a feeling I need to go, like I did a couple weeks ago, and I took 2 of my kids, and we went up there, and we had the best time ever. So, I mean, I love it up there.
That is wonderful.
There's everything you need. There's beach, there's mountains, there's, city. It's a great place, so.
That's awesome. Wonderful. Okay, and now pick another number, please.
Pick another number. I'll pick 30.
Okay, if you could be a professional athlete in any sport, what sport would you choose?
Ooh, that's a tough one. Well, I played softball all growing up, so maybe a baseball, but my kids play all different sports. What sport? Oh, geez. I don't know. Maybe basketball, because I'm tall. You have to be really agile. You have to have really good cardio discipline.
I thought I knew the answer of this one for you, because I thought you would say dancer, like a professional.
Oh, I mean, no, probably not. I think I'm really into basketball right now. My middle son's really into it. And so we are very basketball centric, although my daughter's about to start lacrosse. So we have lots of sports in our house, and I really love sports. So I love watching them. I love playing them. I love cheering them on. So I'm
very nice.
Yeah.
That is awesome. All right, let's do one more.
Oh, gosh. Okay. How about 6?
All right, 6. What is your favorite word?
Can I say my favorite phrase?
Sure.
And it's not really my favorite, but I say it a lot to my children. Knock it off. Knock it off. When they start fighting, and I say, knock it off. I do this at work all day. With fighting siblings, we're not doing this at home. We're Team Gonzalez. Knock it off.
That's great. I love it. Very, very nice. Okay, before I let you go, we will have all your contact information in the show notes. However, somebody who is in need, how do they get a hold of you?
So they can either call my office at, you want me to give the phone number?
Yes.
Okay, it's 818-986-8080. Or you can email me at jgonzalez@oclslaw.com.
Beautiful. Thank you so much for participating. It's been such a pleasure to have you. Thank you, everybody who has joined this episode. We will see you in the next episode. Bye, everybody. Say bye, Jamie.
Thank you.